Good evening. I'm Joe Heath, General Counsel for the Onondaga Nation, and I'm speaking to you from Onondaga Nation territory in central New York. Tonight, we'll talk briefly about some early cases with the doctrine of Christian discovery and domination, review the excuses and justifications used by the federal courts to dismiss the Onondaga land rights action, and then discuss a couple of recent cases that have good initial results, but are still based upon the problematic constructs of the doctrine of discovery and plenary power. And I'm going to use a PowerPoint this evening. And the first case we're going to talk about is the 1823 case of Johnson versus McIntosh, which you heard referred to a couple of times last week by the Onondaga leaders. This is the case written by John Marshall in 1823 that he brings the doctrine of discovery into U.S. Indian law as the foundation of U.S. Indian law, where it remains today. And we need to remember that Johnson himself was a land speculator, as were most of the people we now call the founding fathers, Washington, Jefferson, and that Marshall was busy making money, claiming to buy Indian land that was on the west of the Appalachians, where indigenous nations were thriving, and then also claiming the right to sell that for profit. And so the decision was very self-serving for Johnson, for Marshall, and his ruling class. And in it, he wrote that the Indians were admitted to have a rightful occupants of the soil, that's your limited rate of occupancy, but that their rights to complete sovereignty as independent nations were necessarily diminished, and that discovery gave exclusive title to those who made it. And he went on to claim that this gave the European nations the right of ultimate dominion, which included the right to take the title to the land and then sell it, even though it was still in the possession of the natives. Marshall admits that this is a very far-flung, far-fetched claim, and he says it's very extravagant. But once it's announced and repeated, and if the colonies are all on stolen Indian land, which they were, it becomes the law of the land, and cannot be questioned. This is the beginning of the doctrine, and it goes downhill from there. 130 years later, the Supreme Court handed down the Tiwa decision, which is 1 year after Brown versus Board of Education. Tiwa is 1955. In which this infamous saying is included. Every American schoolboy knows that the savage tribes of this continent were deprived of their ancestral ranges by force, and that even when the Indians ceded millions of acres by treaty in return for blankets, food, and crickets, it was not a sale but the conqueror's will. Is absolutely ahistorical, but this is the kind of writings that our Supreme Court has continued up to today. Because 50 years later, the Supreme Court handed down another infamous case, City of Sherrill versus Oneida. And the facts briefly there was that the Oneida Nation had been purchasing back land that had been stolen from them by New York State within their Canandaigua recognized treaty, and then saying, we don't have to pay taxes on our own land. And the court said, oh no, that's not fair for you to take that position now. And they cite and it's an 8-1 decision written by Justice Ruth Bader Ginsburg, and her first footnote squarely bases the case and the decision on the doctrine of discovery by citing Johnson versus McIntosh, and by writing that under the doctrine, of discovery. Fee title to the lands occupied by the Indians when the colonists arrived became vested in the sovereign. First Europeans, then the States and the United States. This is 15 years ago. So we see that the doctrine is still the foundation of U.S. Indian. 3 months later, the Second Circuit used Sherrill to dismiss the Cayuga land claim. Actually, all that Cayuga had been awarded in the district court was a money award of $250 million. Hard to see how a court can label that disruptive, but they did. And they proceeded to then dismiss the Cayuga land rights because it wasn't fair. And they wrote that they understood Sherrill to hold that the doctrines such as laches, acquiescence, and possibility can, in appropriate circumstances, be applied to Indian land claims, even when such claim is legally viable and within the statute of limitations. And in order to justify this very unusual ruling, they go on to say that one of the few incontestable propositions about this unusually complex and confusing area of law is that doctrines and categorizations applicable to other areas do not readily translate into these claims. In other words, we have a totally different set of rules for Indian land claims than any other litigation in our federal courts. And it's not a system that favors indigenous nations. 5 years later, the same Second Circuit dismissed the Oneida land claim, which had been pending for 40 years. And they're trying to explain this defense that they had called laches in Sherrill, but did not include any of the traditional rules that applied to equitable principles and laches. And so they say that, well, we've used the term laches, but that's a convenient shorthand. And because it's a somewhat imprecise defense that we've created here and handed to the state of New York. And they pointed out that the Oneidas had challenged the use of that defense because the defendants had not established the proper elements. That didn't matter. Ultimately not important because the equitable defense recognized in Sherrill and applied in Cayuga does not focus on the elements of traditional laches. Another example of a different set of rules for indigenous nations. 2 years later, on Columbus Day in 2012, I got to argue the appeal of the dismissal of the Onondaga land rights action in that same Second Circuit. Columbus Day. We did not miss that irony. And they gave us 10 minutes. And 1 week later, they summarily dismissed the case. And they boiled down this evolving defense that they had created, calling it equitable, and said it had 3 factors: the length of time between the historic injustice and the present day. In other words, if your treaties are old, which is what the studies are, then you're in trouble already if you try to go to court. If the court says they're disruptive, that's 2 strikes. And if the court finds that your claims would upset the justifiable expectations of settlers, strike 3. Onondaga land claim dismissed. Those are the same kinds of arguments that we will see in a minute that were handled recently in the federal courts. And that's the case of McGurk versus Oklahoma. 5-4 vote in which Justice Neil Gorsuch joined the 4 liberals, and he wrote the majority opinion. Now, the narrow holding in the case, and that is that the Muskogee Reservation was still in existence, that it had not been terminated, is obviously a good result, a better result than what John Roberts argued in his defense, in his dissent. But there are fundamental problems in this case. I'll get to those in a minute. And he uses some very encouraging sentences. He begins the opinion by saying at the end of the Trail of Tears was a promise. That promise, by the way, was 3.5 million acres in the state of Oklahoma as a Muskogee reservation forever. And the question was raised by Jim C. McGurk, who's a Seminole citizen who committed violent crimes on the Muskogee reservation and had been convicted in state court. He appealed, and his appeal was based on his argument that state criminal law could not apply on Indian country and that the Federal Major Crimes Act should have applied. And the court agreed with him. And they agreed with him because the reservation had not been terminated, or in their nice sterile legal word, disestablished. And they make flowery statements like we hold the government to its word, and if they make promises, they have to keep them. And also somewhat encouraging is that Gorsuch and the majority rejected many of the same arguments that have been used by the state of New York in defense of the land claims and by the counties in trying to retake land that they say they're entitled to collect taxes from the Cayuga and Oneida Nations. And Oklahoma raised that the demographics had changed. And really what they're saying there, and they said it right out, was that, well, white settlers have moved in and they own all the land now, so it can't be a reservation. And they also warned that if the court agreed with McGurk, there would be a huge disruption of their criminal justice system. Gorsuch says, no, you're just throwing up a warning, which is not a license for us to disregard the law. And he said that many of the arguments follow a sadly familiar pattern. Yes, promises were made, but the price of keeping them became too great, so now we just cast a blind eye. Gorsuch said, no, we reject such things. So at first blush, this case really looks groundbreaking. And in fact, too many people have written to that extent. The problem is, even though the narrow result was positive, it's based on plenary power, the presumed right of Congress to end any Indian treaty it wants to at will. And my take on the case is that the debate between Gorsuch's majority opinion and John Roberts' pretty snarky dissent, they're arguing over, well, what are the right rules for how we break an Indian treaty? That's what the case is about. And it affirms and strongly reinforces the illegal claim of the United States government that they have the unilateral right to break any Indian treaty. That's plenary power. Now, Gorsuch is clever because he never uses the term, the words, plenary power anywhere in the reservation, in the opinion. But had Congress terminated that reservation, Gorsuch would have unquestionably ratified that. And the way we find that out is by doing some homework and looking at the cases that Gorsuch cites, particularly for the discussion of plenary power. He cites Lone Wolf versus Hitchcock, a 1903 decision by the Supreme Court. And this is the first time that the court just blatantly says, we have the right to break any Indian treaty we want, and Congress has that right. And so the rules, according to Gorsuch and Lone Wolf, are only Congress can break Indian treaties, but they can do so at will, and it's not even questionable. And so back in 1903, the court wrote that the Indians only had occupancy, which could only be interfered with by the United States, but that the United States would be governed by such considerations of justice as would control a Christian people in their treatment of ignorant and dependent race. Now, this racist language is what Gorsuch relies upon to reach the result that he does in McGurk. And then the old case goes on to say that plenary authority over tribal relations of Indians has been exercised by Congress from the beginning. and that the power has always been a political one, not subject to be controlled by the judicial department. So there's no review when Congress can unilaterally break treaties according to Lone Wolf and according to Gorsuch. When treaties are entered into between the United States and an Indian tribe, it was never doubted that the power to abrogate exists in Congress. In other words, he's claiming that the United States signed these 500 and some treaties, always knowing that they were going to break them. And that's just the way it is. And it's beyond judicial review. So that case was decided on July 9th of last month. And then about 3 weeks later, on July 30th, the Seventh Circuit applied and extended McGurk. And the question there again was whether or not the Wisconsin Oneida Reservation had been terminated because a local village claimed the right to regulate an apple festival that the nation had been putting on for years. The holding was no, it hasn't been disestablished because Congress hasn't done so. And therefore, there's no village jurisdiction. And these holdings, again, and it's much better that that the Seventh Circuit ruled that because it's Indian country, because it's still a reservation, that most state and local jurisdiction power is prevented by federal law. That's a good holding. But in the process of it, they once again say Congress has the right to break treaties. And the reason that these decisions are important today here in Haudenosaunee country is because there are reservations that were recognized by the 1794 Treaty of Canandaigua, Oneida, Onondaga, and Cayuga particularly. This sign still can be seen today on the Cayuga Reservation. It's a 64,000 acre inverted U that sits on the top of Cayuga Lake. And the Cayuga Nation has been struggling to try to reclaim some of its treaty protected property for the last 20, 25 years. And they're meeting fierce racist resistance from the local settlers who put up these signs all over the reservation saying, no sovereign nation, no reservation. Well, we know now that the Supreme Court says there is a reservation. So what does that mean for these disputes between the Haudenosaunee nations here and the local governments? Time will tell about that. We have a problem with Onondaga County that claims the right to tax property that the nation buys back. So you have your land stolen, you buy it back, you ought to have the whole parcel. They claim the right to tax that, even though it's within the Canandaigua Reservation. And if the taxes aren't paid, which of course we do not do, because the law says we do not have to, they try to take the property back. That's what we're facing today. And we could talk about those issues more in another session, but that's what I really wanted to share with you today, that as good as McGurk and the village of Hobart are, and again, they're narrow holdings that the reservations have not been terminated. Those are good results. But they reaffirm plenary power that the United States claims that they can break any Indian treaty or any part of an Indian treaty at will with no consequences. Thank you for listening.